Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathon Kappy.
And I'm Boris.
Welcome to Hull on Estates. You're listening to episode number 709. And today we are going to be discussing consent judgments, what they mean, how to use them, and how courts will give effect to those consent judgments. How you doing, Boris?
I'm doing well. How are you?
Good. 2025. Can't believe it came so fast. But now we're here.
Rolled around the corner. It was super quick. The Christmas holidays just passed. At the time of this recording, it's New Year's Eve. So, we're jumping into the new year in less than 24 hours.
We had some snow for Christmas, and then the rain came and it got warm. I'm okay with that.
I would prefer a white Christmas, actually. We did get a bit of a white Christmas.
We did have a white Christmas. It rained after Christmas.
It rained after Christmas, yeah. So,
all right. So today we're going to be discussing consent judgments, and some people may not be using consent judgments properly or effectively. There's certain things that consent judgments can do for you in terms of settlements that parties that are into, but there are things that they can't do. And I think that this decision that we're going to talk about, which is the Johnston McLean decision of the Court of Appeal, really helps clarify what it can be used for, what it shouldn't be used for, and how the courts are going to interpret the effect of a consent judgment. So why don't we dig in? Why don't you talk about the case a little bit, and then we'll get into talking about what it means.
Sure. So to provide a summary of the case, as Jonathon, you mentioned, is Johnston McLean. It comes from the Ontario Court of Appeal earlier this year, 2024, and the issue at the heart of this case is consent judgments, and it arose after the death of the deceased Margaret Johnston. She owned a $1.9 million farm, and she had 4 daughters. Mary and Karen were the appellants, and Laura and Elizabeth were the respondents. Now, all 4 of her daughters were named beneficiaries. They were given equal parts of the estate, and they were also all appointed the estate trustees. The dispute in this case arose from how the farm in particular would be divided. And prior to this case, there was another court proceeding, and the result of that court proceeding to determine how the farm would be divided, 2 key documents were executed. And the first was the minutes of settlement, and then the second was a consent judgment. So dealing with the minutes of settlement first, the minutes stipulated that the appellants would pay the respondents around 400,000 Canadian for the farm. And this sum was agreed upon based on the farm's appraisal value in 2014. And the minutes also provide for other technical elements regarding the sale. So things we see in the sale of any type of real estate property, like a closing date, the transfer terms. So there were several terms related to the sale of the farm. So at the same time, though, the parties agreed to a consent judgment because they were in the midst of a court proceeding. So this consent judgment was entered and issued by the Superior Court of Justice. This consent judgment, however, does not explicitly refer to the sale of the farm. However, interestingly, the consent judgment did mention that the document itself was made in accordance with the minutes I just mentioned, and that the parties agreed upon those minutes. And further to that, the minutes themselves were not ever attached to the consent judgment as a schedule. So after both documents were executed, the parties initially started working together to transfer the farm per the minutes, but ultimately they were unable to cooperate as further tensions arose. And as a result, the appellants filed another application seeking the court to declare that the consent judgment constituted an order for the sale of the farm. The application judge interpreted the consent judgment based on the dictionary definition of the words used in the judgment. She found that based on this interpretation, the sale of the farm was not included in the consent judgment. However, on appeal, which is the case we're discussing now, the central issue was whether, again, the consent judgment included the sale of the farm, and the Court of Appeal agreed with the judge, the end result, but they held that the application judge erred in her approach, that is, interpreting based on the dictionary definition of the word. So Justice Auergen, writing for the Court of Appeal in our case, provides the correct approach in interpreting consent judgments. And he writes that consent judgments are a species of contract and should be interpreted using contractual principles. So if we cast our minds back to law school, we're talking about principles such as offer, acceptance, consideration, but most relevant here is intention. Consent judgments require understanding the parties' intentions and the context in which the agreement was made.
And I think that's really important. Okay. So I think when you're talking about what is a consent order, okay. So normally when a court makes an order, a judge weighs both sides, hears arguments from both sides, and makes a ruling that is fair or in accordance with the law as the judge determines, okay? And that is your order. When you're talking about a consent judgment, you're talking about something very different. You're talking about an agreement amongst the parties that the judge signs, but it's not the product of an adjudication process, okay? And so it's a very different document, and it has different implications. I think that's what the Court of Appeal was getting into here in terms of how do we interpret things, okay? And it's been a long-standing principle that consent orders are contracts. I mean, they're incorporated into orders, but at the end of the day, a consent order or a consent judgment is simply a contract between the parties that are consenting. And so when the court gets into, how do we interpret these things? The court rightfully says, well, if it's a contract, then we have to interpret it in accordance with the terms of a contract. And so what the court says is, based upon the principles of contractual interpretation, the court should read consent orders as a whole, given the words use their ordinary and grammatical meaning consistent with the surrounding circumstances known to the parties at the time of formation of the contract. It is a contract, all right? And if you look at the history, the legal history of consent orders, the same thing applies when you're talking about varying a consent order or a consent contract. It's the same principles, setting aside a consent order or a consent judgment. It's the same contractual principles of mistake, misrepresentation, and all those things that apply to contracts. And so it's not just a matter of looking at the words used. Context really matters. Just as context matters in the course of coming to the agreement, the minutes of settlement, the same thing applies when it comes to the consent orders, because it's just a contract. And so that really leads to what is the purpose of a consent order? Why do we need consent orders, right? Sometimes you need orders, all right? Your parties come to an agreement. If you've got minors or incapable parties, Rule 7 says that these orders are not binding upon those parties unless they are approved by the court. So there I can see, all the parties may consent, but the court has its own role, right? No one is consenting on behalf of the court. The court has to undertake its own review, determine that it's in the best interest of the minors or the incapable persons, and those terms get incorporated into an order. Even though if it's on consent, the judge is a third party to that who has to approve it, all right? But when you're talking about settlements with people who are all capable, who are all adults, when do you need consent orders? When is the minutes to settlement not good enough? And I think that sort of, people don't necessarily turn to mind, well, why do I mean, I know I got to go back to court to dismiss the proceeding, all right? So I know I'm going to get an order, but why do I need more than that? All right. And so in my opinion, and it's just my humble opinion, people are overly concerned about building in terms of the settlement into a court order. Like it's going to have some greater weight to it if it's built into a court order versus just being in minutes of settlement. And I think the Court of Appeal here is saying, well, there really is no difference between it being in a minutes of settlement or it being in a court order. Okay. Where it has its advantages is where you need certain powers to carry out the minutes of settlement. So if you need to empower someone with an authority to go get a document, to transfer title, to do things like that, well, then a court order is really helpful because you need another step beyond the parties just agreeing, or there's other paperwork with directions and authorizations and things that you're trying to skip by just having a court order. Yes, Boris, you have the authority on your own to transfer title from me to you, and you can sign all the paperwork, right? That, the registrar can accept that when you're transferring title, you don't need to get all the other documents. Or if you need somebody with authority to go chase records or something like that. Well, then I think an order is really helpful because it empowers you where it's not necessarily just the parties agreeing, but you need a court to give someone the authority. But just simply to incorporate terms of settlement into an order for the sake of having it in an order, I think what the court here is saying, well, a court order is no better than a contract.
Totally.
So, in terms of when I think that people need to use it a little bit more strategically because even it's an interpretation, the court is saying, well, we're interpreting it as a contract and context is everything, and I think more and more you're seeing that, in interpreting documents, context is now becoming paramount, right? You see interpretation of wills, context at the time that the will was created matters, right? We're no longer looking at simply when there's ambiguities. It seems to always matter now. When you're dealing with consent orders or contracts, context matters. Even if you're looking at statutory interpretation now, we had a decision this year, the Ingram and Cullinich case, which was limitation periods. And that one was referring to a 2023 case, the Bank of Montreal and Iskandarov, which was also a Court of Appeal decision. When they're talking about statutory interpretation of limitation periods and which limitation period applies, they're talking about context, even in that case, right? I mean, in that case, the factors that they're now taking into consideration with statutory interpretation is the historical approach to limitation periods and issues, including legislative purpose and the relevant statutory limitation periods, judicial approach to interpreting limitation periods, nature of relief sought, language used. I mean, we're now talking, when we're trying to understand what the words on a piece of paper mean, context is really important. I think more and more the courts are saying and acknowledging context matters. You can't just look at the words because what the parties were doing at the time, what they were discussing, what the email exchanges were matter. And I think that that's what they were doing. And then that's why they get into later in the case, the Johnston case we're talking about is about repudiation, right? So they had originally, as I understood it, agreed that, two of the parties were going to buy out the other two from the house. And then they were talking about listing the property for sale. And they were talking about, well, hold on a second, your original agreement was to buy one the other out. And then they sort of abandoned that approach and went a different way. And that's why the court started talking about, well, was there a repudiation of the original agreement? And there certainly was a repudiation. There was no doubt about that. And then the question became, well, was that repudiation accepted so that the agreement came to an end? And the court, both lower and the Court of Appeal, said, yes, that repudiation was accepted. And so parties agreed to abandon that term of the agreement. And so, yes, they were fighting over a court order, but really this was a contractual fight. So did they need a court order for that provision? Probably not. Interestingly enough, the court was focused on the order and not so much on the minutes of settlement, right? Because the minutes of settlement were also the contract. I guess the court wasn't asked to deal with the minutes, the underlying contract. But I think that would have been a more interesting sort of analysis. What do you think? I mean, I've spoken a lot. I've given a lot of thoughts.
I think, well, in terms of the consent judgment itself, I completely agree. Consent judgments are, in its most unadorned definition, I think, it's an agreement between parties. It's kind of plain and simple. And it seems like almost, I don't know, sneaky in a sense, where in this case in particular, where some of the terms were not put in, or they're not exactly replicated from the minutes of settlement and the consent judgment, and the court applied a very surgical analysis. They're like, this was here, this was not, and they essentially ruled that the sale of the farm is not in the consent judgment. It was very clearly intended to be deliberately removed. And then there was also evidence deduced from email correspondence that demonstrated that some of the parties did intentionally leave it out of the consent judgment. So I think it was very clear, and I think that it was a contractual analysis. Applying that was the right way to go. But in terms of other key takeaways,
But even still, though, but I mean, even still, isn't that sort of a red herring?
yeah,
I mean, let's say the term was built into the order, right?
right,
So, I mean, the setting aside a consent order are the same grounds as setting aside a contract.
exactly.
We're not, setting aside, the rules of procedure provide for how to set aside, vary, amend an order, right? And they talks about an accidental slip or omission. They talk about all these other things something not adjudicated on. Those things don't matter when you're talking about consent judgments because you're not talking about an adjudication process. You're talking about a contract.
Mhm.
And so contractual principles apply. And so does it matter if, I mean, I guess that's my question is, does it really matter whether, the agreement was built into the consent order or not? I mean, it's still a contract, whether it's in the minutes, whether it's in an order, it's still a contract. And if one party repudiated and the other party accepted, isn't that good enough, whether it's in the order or not? I guess I walk away thinking it doesn't matter. It wasn't one of those terms that it mattered whether it was in the order or not. If it was a contract, either the parties agreed that that term was at an end, or they agreed to vary the term, or they didn't.
Mhm.
So, but I think that concludes our podcast for today. That's sort of all the thoughts I think we have. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And Boris saying.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website. Have a great day.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.